Okay, can everyone please take a seat? We have an excellent panel ahead of us. Like I hope everything else has been excellent. As the previous panel pointed out, we have some serious barriers to overcome. And we're pleased to say that there are some examples in our law of people who have taken up the challenge to see how we can improve the state of lives for children through the law. So I've asked them all to self-introduce, and I'll turn it over to Barbara Findlay to begin.
I don't know about the rest of you, but I'm absolutely furious after that last panel and at the way we're collectively treating children. But that said, it is my very great pleasure to introduce one of my very favorite people in the world. Harriet Cunningham is from Comox. She lives on 5 acres. She's active in her 4-H club. She's 12 years old. She has a 2-month-old meat goat called Blotus. She's a transgender girl, and she's one of 9 complainants in a human rights case to have all gender markers removed from birth certificates in British Columbia. And with that, Harriet.
Good afternoon. I would like to begin by sincerely thanking you for inviting me and for taking the time to listen to my story and learn about me and others who feel that it's our right to have gender removed from birth certificates. My story begins at a very early age. I always knew I was different. Looking back, I now know that I was always a girl. As far back as I can remember, my body didn't fit who I knew myself to be. I played with dolls, loved coloring and Play-Doh, and I liked wearing my mom's skirts and high heels and was always drawn to fancy things. My mom and dad did their best to figure things out. My birth certificate was saying I was a boy, yet I knew I was a girl. They went to so-called experts. One person told my mom that it was her fault for being too close to me. Another person told them that it was okay to wear dresses in the house, but not out in public. My old GP told my mom, just tell him he's a boy. While my parents were trying to figure me out, I already was telling people that I was a girl. I was frustrated and angry that my parents and others just couldn't get it. I really believe that if there had been no gender marker on my birth certificate, would have been easier for my parents to just let me express myself in my chosen gender. If I had not had an M on my birth certificate, I think my mom and dad would have just let me dress and be as I wanted. I would have gone to kindergarten as a girl, and voila, many of the problems that I experienced would not have arisen. When I entered kindergarten, I thought I was an interesting little person. I felt the need to express myself, and my outward appearance began to change. I wanted to grow my hair longer, and I needed to wear things that I knew in my heart made me feel myself. Finally, I stated very clearly that I was a girl. My mom and dad were finally educated, and I began living my life in my chosen gender. My choice to express myself, who I knew myself to be, started a series of awful discriminatory events that lasted about 5 years. My parents went to my old school and did a presentation at the staff meeting and tried to educate the teachers and administration on what was going on and what my rights were. However, at this school, I was constantly being asked, "What are you?" I know people were asking whether I was a boy or a girl, but I knew that was none of their business, and it didn't matter. But it hurt me. I would just stand my ground and simply reply, "I'm a person." People would ask inappropriate questions like, "Have you had surgery yet?" I distinctly remember trying to talk to the principal and tell him how wrong it was to treat me like this. And he replied, "Well, it was sort of true." And that was it. I was called he, she, and told to use the staff washroom. Eventually, I put my foot down and walked bravely into the girls' washroom. Nobody tried to stop me. Most of the teachers would still insist on dividing the class into groups of boys and girls. They would insist that I join the line of boys, even though I was desperately trying to tell them otherwise. In the end, the staff and students at my old school were not willing to make the effort to understand the real issues. I guess because my permanent school record still had an M on it, they thought they were treating me fairly. The mistreatment continued, and I knew I had the right not to be treated in that manner. I was miserable. I couldn't stand it much longer. Almost 2 years ago, at the beginning of grade 5, there was one final incident. I look back on it as the last straw. When my dad came, I was curled up in the fetal position, crying uncontrollably, sweating, and completely incoherent. I knew I couldn't go back. My new school is much better. The administration and staff took the time to get educated. I have friends and classmates that treat me with respect. I feel so comfortable there. Because of those traumatizing experiences, I still have trouble hearing names or seeing people from my old school. I play a lot of basketball now, and if I ever have to play at my old school, stepping through those doors fills me with anger. I know that it's negative, but if I hear my old principal's name, I can't help but cringe. I'm seeing a counselor and trying to work through some of this negativity. She's treating me for some symptoms of post-traumatic stress disorder. In the community, my frustrations were similar, though not as harsh. I remember my mom trying to register me for girls' gymnastics. At first, the gymnastics coach said no, due to what she saw in my birth certificate. My mom brought to the coach's attention an article from BC Schools of Sports, which explained my rights. My mom told her that she would seek legal advice if I wasn't allowed to participate. The coach then changed her mind with hostility and allowed me to participate. One of the worst memories I have when I was little was when I was signed up for a mixed baseball team. I saw the form on our kitchen counter and circled that I was a girl. My dad said, "We're not going to get into this," and circled that I was a boy. When I went to the team, I told everyone that I was a girl. But one of the parents who knew my parents told their child and his friend that I was a boy. These two harassed me the whole season, and they were always calling me man. I would characterize the first 8 or 9 years of my life with a few words: anxiety, frustration, anger, worry, and despair. With what I know now, I really feel that there would be different words to capture my early childhood if I was not forced into a label that didn't fit. In other words, no gender on my birth certificate. When we would go visit my grandparents in California and go through border security at the airport, my dad would always say, "Be quiet and let me do all the talking." I would protest and always want to make an issue of this. I would often get extra long, lingering looks and sometimes questions about who I was. This really affected my sense of justice and my emotional health. I wanted to explain myself to these people. I wanted to tell them that this was wrong and that I was really a girl. I was desperate to make the M disappear. My grandma and I wrote letters to everyone we could think of, asking for gender to be removed. We applied for birth certificates and provincial care cards without marking anything in the gender boxes, which was denied. It was a big deal to officially change my name to Harriet Cunningham. Eventually, our provincial government passed legislation which allowed me to change the gender markings on my birth certificate without reassignment surgery. I was allowed to change my passport as well. Our province was the first to do something for trans youth, and while I was happy, I knew that no gender was the right route. Ever since I was little, I had a very strong, passionate sense of justice. I tried to figure out the difference between right and wrong in certain situations and would always get very upset when I felt I or other people were being mistreated. I am a part of a tribunal asking the government to remove gender from birth certificates, and Barbara Finley is our lawyer. I believe that if my birth certificate had no gender on it to start with, I would have never had to face the problems that I faced. Though my situation is certainly better now that I have a marker that corresponds with my gender, I would much prefer that everyone have birth certificates with no gender markers. Because in that case, if someone wanted to know my gender, I could just tell them. I have learned that there are so many people that that may be intersex or that may not identify with either gender, and I think it's unfair to make them choose. I've learned that many people in our minority are not as fortunate as I've been. Although understanding about me was at first very difficult for my parents, I'm very lucky to have my family support me, and people like Barbara working on our behalf to protect and extend our rights and freedoms. I have learned that young people like me are in a very vulnerable position. There are so many people who do not understand the real issues facing all trans people, but especially young people like me. I think having no gender on birth certificates would be a great help to people who do not have the support I've had. As I said, I consider myself very fortunate and would not change a thing about who I am. I'm a fourth-year 4-H member. I play basketball on the grade 6-7 girls team, and I swim 4 days a week. However, I have had to endure many years of mistreatment and discrimination. Looking back, I can't help but think how much easier my life would have been so far without been labeled at birth. I also think that I would have been much simpler for my parents to navigate my world if there had been no labeling of my gender at birth. I could go on and on about how important it is for our next generation to grow up without needing to make gender a defining feature. By choosing not to put a label on a birth certificate before you know who someone really is will not create confusion. Nobody loses any rights by letting go of misconceptions. I want to continue working to educate people and speaking for those that do not have the support to be heard. Thank you all for bringing me here and listening to my story. I hope that you can help to make life easier for people like me.
I call it animal wisdom, my dear. There's the next generation. I listened really closely this morning to Elder Bruce and talking about reconciliation and being part of healing and not harming. And so I'm going to talk to you about trans kids. And the way I'm going to talk to you about that is I'm going to talk to you about the way we can change our culture so that trans children don't continue literally to be born into discrimination. I'm going to also remember the wisdom of my Wet'suwet'en people who, like other First Nations, have a venerable role for children who we call lesbian, gay, bisexual, or transgender. In many First Nations communities, those are two-spirit children, and those children are honored, not reviled, for the role and responsibility that they carry. All right. You've got 4 minutes for Trans 101. Get ready. All right? This culture teaches us myths about gender. They're all wrong. And I want you to listen closely because probably you've never heard them identified before. And I'm telling you they're all wrong. And I don't have time to tell you all about why. Are you ready? First, you can tell a child's sex by visual inspection at birth. There are 2 sexes. There are only 2 sexes. Sex and gender identity are the same thing. The sexes and the genders are male and female. Sex and gender are unchangeable. A person's gender is and should be immediately ascertainable by looking at them. The two genders are opposite each other. The two genders are complementary, brackets, heterosexuality. One gender legitimately has more social power than the other in the world. Gender identity and sexual orientation are the same thing. All of those are not true. Gender identity is the sense that a child has of their own gender, which does not develop for several years after they're born. One's gender identity is, in law, trumps your genitalia. That is to say, who you know yourself to be is who you are, period. People whose gender identity does not match their genitalia challenge those assumptions I listed. The biggest challenge are people who identify as neither male nor female, or both male and female, or agender, or some other gender identity. So I've got 6 rules for you. The first is locate yourself. Because if you don't recognize your own location of privilege, for those of you who are cisgender like me, whose head and genitals match, we carry all those assumptions, and that's baggage that's going to get in the way. Second, pay attention to amplification. A child, a trans child, is, if she is in a family, they are in a family, he is in a family where the family is already marginalized by race or by class or by recent immigrant status or language, then it is for sure that child is going to have an impossible time, because they cannot afford to give up the safety of their family against the cultural oppression, but they cannot afford to not to tell their family who they are. And so they kill themselves at a rate higher than any other group. So what we do with gender kills our trans children and our intersex children. The third thing that I want you to do, cure your ignorance. I wrote a paper. It's in your materials, and I really mean that. I mean, like, as responsible people in the world, it is our job as cisgender people to figure out what the real truth is as opposed to what we've been told. The fourth thing is interrupt patterns of oppression. And what that means is every time you see MF anywhere, anytime, speak up. There are no neutral positions. And every time there's an M and an F, that trans kid has nowhere to go. And when I say nowhere to go, I include nowhere to pee, and trans children routinely have bladder damage. Every gendered space, every public washroom, every form, I'll get you if you have forms in your office with MF on them, all need to be changed. Finally, 5, support intersex and trans children. And the way you do that is, do not assume that everybody in this room except Harriet is cisgender. We're not. You're not. You only know somebody's gender if you ask them. Finally, be gentle with yourself and with each other when you make mistakes, because we cisgender people make lots and lots and lots of mistakes. Use the pronouns that trans people ask you to use when you're referring to them. Pay attention to the ways in which you organize the social world that you participate in, and make the world a place where trans kids don't die. Thanks.
I thought this was a voting thing. I was quite captivated. Maybe everyone has one and they can vote. My name is Ardith Walpetco Hoidelks Wacom. I'm a member of the Tlacatmic Nation, just from the interior of BC and stretches down into Washington State, although we're not federally recognized in Washington. The area that I was asked to come here to talk about today is the use of human rights legislation or initiatives in the context of Indigenous children. And I want to talk about two particular areas. One, a case which is being brought on behalf of the First Nations Caring Society and AFN in the Canadian context, and second, a recent case which has just been decided and was supported through the ACLU in the United States. And one of the things when we talk about rights of children, the image that I get for Indigenous kids, particularly in the context of child welfare, and this is an image which has stayed with me. So within my own nation, when we talk about laws, we have to talk about laws as images. We don't tend to understand laws outside of images, so our understandings are very visual. And when I think about Indigenous kids and the Canadian law or Western law, I come to this example that happened to me when I was about 13 and I was a bit of a delinquent living in Salmon Arm, the interior of British Columbia. It was in the winter. And this is just an image that has stayed with me, tied tightly to this area throughout my lifetime. I had stolen, it's terribly embarrassing, with a friend of mine a shopping cart, and we wanted to go and push it over the edge of the ice because we thought that would be cool or fun. I'm not really sure. We clearly weren't very intelligent because if you think about it, you can't push it over the edge of the ice because as soon as you get near the edge of the ice gets thinner and thinner and thinner. And there I was, proudly pushing the cart. And I fell through the ice. It was the middle of winter, just the two of us there. And I couldn't get out. I was stuck. I was scrabbling and scrabbling and scrabbling. And I kept putting my weight on one spot, on one spot, on one spot. And the ice kept cracking and cracking. And if you've ever been in that kind of cold water, ultimately your arms sort of start to, it doesn't really hurt. You just sort of start to shut down. And then something occurred to me that I should make like a starfish and distribute the weight. And because I distributed my weight, I was able to get out of the water. But when I think of Indigenous kids, and we hear numbers like this, like we hear 54% of the children in care in BC are Indigenous. Less than 5% of the population is Indigenous. That's ridiculous. And you know what those kids are? Those are kids flailing around in the ice without help. They're radically isolated. And one of the things that I think is really important is that they're there oftentimes without representatives of their Indigenous communities or Indigenous nations. And one of the things that I'm really fascinated by and talking about today is the use of different legal tools, because I think for so long in the Canadian context we may have said these kids are in care because their parents have made, like, it's their parents' fault, it's their family's fault, that's why they're there. We haven't bothered to look at this as an issue of systemic discrimination and ask what it is about the society that systematically puts the kids there and isolated in that way. And so these two examples I think are really interesting because for me they talk about that. They talk about what we can do to address that disproportionality. So the first case is a case coming from Canada, and it was a case brought to the Canadian Human Rights Tribunal by the First Nations Child and Family Caring Society together with the AFN. And what they're alleging is discrimination on the part of Canada, which they say has led to both in funding and in policies and procedures on reserve, which has led to increasing numbers of, so this disproportionate number of Indigenous kids in care. And they're saying that that disproportionate number of kids in care isn't neutral, that because that these children suffer a real detriment. So we know that when children are coming through care, that the likelihood of them graduating, going to post-secondary is lower. The chances of them graduating right into the criminal justice system is higher. All sorts of outcomes across the board are much worse for Indigenous kids when they're put in care. And so the First Nations Child and Family Caring Society and AFN tried to use the human rights legislation as a tool to address that. And the basic four arguments that they're making as basis for discrimination are that first, First Nation children on reserve are not receiving comparable child welfare services with other Canadian children to their detriment. So they've assembled a massive information from across the country, and it includes stuff like children on reserve are funded at 22 on an average less than children off reserve. In some areas that's a lot higher. But what their argument is that by providing less funding on reserve and putting far more conditions on the delivery of services on reserve, that what in fact the government has done is it's incentivized taking kids into care, because they're not supporting, not keeping children within their family or within their nation. They've argued that Canada's failure in delivering these services to take into account the historical disadvantages suffered by Indigenous peoples has impacted those services. So, for example, if you're coming from a history where you have generations of children or parents who haven't been parented themselves because they've been raised in residential school, or increasingly now we have multi-generations involved in the child welfare system, that to treat those people equally. We saw this morning the people looking over the fence, and we had to put steps to get people equal, that if you're dealing with Indigenous children and families, that to treat them equally in that context means you can't pretend that they just got there, that they got there with the same parenting history, that you have to look at that history, and treating them equally means taking preventative measures, looking honestly at that history and saying what that should mean and reflecting that in decisions. They're saying that Canada's failed to provide culturally appropriate services. And this is a really important one. So what the AFN is arguing, I don't know if a lot of people know this, but historically, provincial child welfare law didn't apply to Indigenous kids. Only federal law applied, and they passed a law in 1951. They amended the Indian Act to referentially incorporate all provincial legislation. So what they did with that one passing of legislation is it meant that now the provincial law could apply to Indian kids. And then at that same time, the federal government started making contracts and hiring the provinces to deliver these services on reserve to Indigenous kids. But the long and short of it is that Indigenous peoples never consented to the Indian Act. They certainly didn't consent to the Provincial Act, and they have their own laws in place. And under Canada's policies right now, there's absolutely no funding. Canada refuses to fund recognition of any Indigenous laws or Indigenous ways of dealing with this. So it's a jurisdictional muddle that's imposed, and this is what the main argument that the AFN as part of this application is forwarding. Final one is one of the main other arguments that they're making is that in the Canadian context, there was an agreement. There was a child who was born and he had severe disabilities, and his parents placed him in care because they couldn't afford to care for him at home. So he stayed in the hospital for 2 years, and when he was ready to come home, the province and the federal government kept dickering about really stupid things, like who was going to build the ramp, who was going to pay for little things like that. And they argued about it for so long that they left him in the hospital for another 3 years, and he died because his parents couldn't afford this. And as a result of that, the death of that child, Jordan, the federal government and provinces and territories agreed to Jordan's principle, which is in essence that when a dispute comes up where there's a jurisdictional issue about who should pay for it, whoever has first contact will pay, and they'll argue about it later so that they won't leave that child alone. So we're expecting a decision on this case maybe within a year. It should be soon. I see that I'm running out of time, and it's a very interesting thing also happening in the States where the numbers are very, very similar. And this is a case called the Oglala Sioux tribe versus Van Hoonick, which was heard in the Pennington County of South Dakota. This was a case supported by the ACLU. And this was a case in this one county where over 4 years, 500 Indian children were taken into care. And they actually had some people go in and observe the court hearings. Some of the court hearings were 60 seconds. The judges never, in this particular county, advised the parents that they could make representation. The state never had to call anyone. They did it all. They filed out forms or affidavits or statements. The parents weren't advised that they could appear. And in that case in those 4 years involving 500 children, the parents lost 100% of the time. So in 100% of those cases, the children were taken. And this case was brought because a lawyer who does something else happened to arrive early and saw this, and he thought this is a vast violation of rights, and he contacted the ACLU and brought this case. But it's interesting because there was just a success within the past year, and these two cases, I think, highlight how we can use human rights legislation to shine light on this disproportional representation, and I think they both offer some sort of hope and illumination for the future. Thanks.
Okay, it's the end of the day, close to the end of the day. My name's Sarah Roush. I'm a private practitioner right now, representing children along the way in various interdisciplinary aspects of the law, which is quite unusual, actually, and I didn't really intend to do this, but it seems to be the way my career as a lawyer has developed. Prior to that, I was a groundskeeper for many years and other things, so I come to law as a diverse person, and my practice is very diverse. So I've represented children. I have been successful in a Section 203 application. I've represented children in family law, in CFCSA law, in criminal justice and human rights cases, and BC Review Board cases, and so on. And it seems like there's always something about children in many of the cases that come to me. I'm honored to be on this panel and see the diversity and hear the diversity, and I'm especially honored today to hear from the children who've spoken to us today. How difficult it is to try to represent children, or anyone for that matter. How do we represent, and what does that mean? So I'm going to talk in the context of, well, let's remember what Judge Bowler described context as, which I think she said, taking reality and meshing it with the laws. Now, that's a good enough description for me today. If we take the reality and mesh it with the laws, that's the context. I'm going to talk about this from the context we haven't heard too much about today directly, which is from a baby's perspective. So it might be thinking of rights from a baby's perspective. So we have an international convention, we have the charter, we have BC laws, we have human rights laws, and they're all based on rights. And what we've been talking about a lot today are rights, individual rights. When you think about babies being born, as I used to say to my students, where do rights come from? When a baby is born, what do they have the right to? And there might be some disagreement about that, which is okay. But you would think that the first right a baby has when it's born is to its mother, right? Because it's been born, its mother is right there. And you would think that's a starting point for understanding rights, or I'm going to ask us to think that for a moment. So the context of access to rights for children, and babies in this case, to me begins with the right to your mother when you're born. Because how do we get rights anyway? But I'll just parenthesize that for a moment, because really it's really interesting if you start thinking, how do we get rights? What are inherent rights? What are rights? How do we get them? Who gives them to us? Okay, back to the baby being born. I was very fortunate and honored to be involved in a case that went to the BC Supreme Court several years ago. I represent prisoners a lot, or people that are incarcerated, and especially women who are incarcerated, and especially Aboriginal people over my career as well. So all those things converging. I went to Alouette Correctional Centre for Women one day and met Amanda Inglis and another woman who, Amanda Inglis was pregnant at the time, and the other two women I met that day had small children in Alouette Correctional Centre for Women. After leaving the jail that day and out in Maple Ridge and driving home, we started hearing rumors, or I think I heard them that day, that the mother-baby program that was active there was going to close. So there was a mother-baby program that began at BC Correctional Centre for Women, and when Fraser Valley Institution for Women was built, it migrated to Alouette Correctional Centre for Women. So there were 11 mothers and babies that successfully went through a program where they could stay together in the jail. And there was a pediatrician who attended, and a lot of support for the mothers in a special wing of the jail where they could stay, and for the babies, where they could stay with their mothers. That program, we heard, was going to be closed. So that became the little seed of an idea. I had one of those moments where I felt something's wrong with this. There seemed to be no problems with the program. The women were certainly concerned, especially Amanda Inglis, because she was due to deliver in a few months and was concerned. But everyone seemed concerned about it, and there didn't seem to be an explanation. So we tried informally to inquire and ask questions. At the time, I was the director and supervising lawyer of the UBC Indigenous Community Legal Clinic. And in my role as the supervising lawyer there, we were able to take it on as a file and begin to ask questions. And later we had gained the interest of Faskins Martineau as well, which is a prominent law firm everyone knows, I'm sure, and lawyer Jeff Cowper and Kevin Nakanishi, who agreed to assist with the litigation that ended up being the litigation which challenged the closure of the program in the jail. So this is the context in which we advanced not only, and this was important to me from that day that I drove away from the jail, that not only would we advance this idea of the mother's rights, which really was not nearly as important as advancing the idea of the children's rights, the baby's rights, the unborn child who was going to be born, to stay with his mother once he was born. And it ended up weaving its way through the courts and becoming a full-blown trial in BC Supreme Court, which was a very rewarding and interesting in terms of creating the record, voluminous record before the court, and arguing from the UN Convention, from the position of the charter and the rights of the babies as well as the mothers. Fortunately, the judge engaged with everything we said, which was amazing. Fortunately, in terms of access to justice, we were able to fund it with the generous contribution of Faskins Martineau and also the funding of the clinic, which was funded by the UBC Faculty of Law and the Law Foundation. So interestingly, and I've referred to some of the, I don't know if the cases, I guess it's not up on I don't have a PowerPoint, but anyway, I've put some excerpts from the case in the materials. That's kind of less interesting to me today, though. Sorry, to talk about. Then I wanted to build on some of the things we've heard about already today, both in terms of thinking rights, in terms of thinking reconciliation, in terms of thinking who is in our jails. So we've heard of overrepresentation of Aboriginal people in the child welfare system, overrepresentation of Aboriginal children in the jail system. It was a controversial case, and of course it's controversial on many levels, as are many cases. But when you think just about the rights of the child to remain with his or her mother What's controversial about that? And that was why we were able to really stand behind the case and present overwhelming evidence about, from a health point of view, how that was a benefit. So it was a very interdisciplinary approach too, and there were a lot of considerations from the medical system and data and evidence that we put before the court. But going back to meshing the law with the reality of the children, when young Damien Inglis was born, he was born actually premature, about a month, I think, premature, and he was very healthy. And at that time, the program was just being closed. So it was determined that Amanda and Damien could not go back to ACCW together. And fortunately, we had a doctor in the first square unit of BC Women's Hospital who said that he would not release Damien at the time until there was something decided. And we were having meetings with the ministry and so on. The ministry was going to apprehend the child because there didn't seem to be an option. And fortunately, the definition in terms of health included the right for Damien to stay together with his mother. So they just kept him in the hospital, even though they were both releasable medically. The mother was, the son was. But because there was this risk to them being able to stay together, Dr. Ron Abrams wouldn't release them. And he was Damien's pediatrician. So I'm just saying this as an example of how an interdisciplinary approach to thinking rights in terms of beyond the individual, beyond the little boxes, the big boxes, beyond the ways we each approach our own job in representing people and think maybe more broadly, what is a right? How do we get rights? How can we stand behind rights in order to provide access to justice? So I want to leave lots of time for answers to questions because this was a very interesting panel, but I just wanted to touch on some of those things and to continue the conversation of some of the focus that's come up today with respect to access to justice, including dignity, integrity, what we as practitioners do. And if we think about a baby, who more deserves that in terms of access to justice, and who more deserves our attention and our ability to listen? I mean, we're all speaking very cognitively with language. A baby also speaks, and anyone who's had one in their home knows how they have a way of taking over. So there's that power. I mean, it's an honor to be able to listen to babies and to recognize the rights that they are born with, beginning with the right not to be separated from their mother, unless there's a child protection concern, of course. In this case, of course, there weren't any, and it was only with the blessings of the ministry that children could remain with their mothers in ACCW. So the decision I could go on about is, to me, it's especially fascinating because it's a very plain language decision. So it is written in a way that probably Harriet and others could actually understand, which is great, and that to me that honors again the ability for children to have access to the law and the meshing of both of the reality and the law. So thanks very much.
It's Lucy Mc Sweeney. It's an invitation if there might be other examples. Harriet gave a powerful example about what if you didn't label a baby as to gender? What if you let that baby grow and then tell you what their gender was? And then Sarah's, talked about what if you looked at a mom's incarceration as a baby's right to have access to the mom. In my early years in praxis, I represented a woman in human rights complaint who was thrown out of a restaurant for nursing at the table because her other kids were there to eat the chicken wings. She was nursing the breastfeeding infant. And in the course of it, I became all charged up and wanted to talk about the woman's right to breastfeed wherever she wanted. I wasn't yet a breastfeeding mom myself. And finally, that my teacher in this, my client said, Lucy, it's not really about my right to breastfeed. It's about the baby's right to eat. So we actually got a resolution with the Human Rights Commission where they did posters that advertised the right, because it turned out the restaurant didn't know what their obligations to the woman were, and the mom didn't know what her rights were. So nobody really knew. Nobody was bad or evil, but the ignorance really impacted this woman and the baby who didn't get to eat when all the siblings did, right? So I'm wondering if that reframing, looking at from the infant's or the young person's lens, is something that's right in front of our eyes in other instances too, maybe right in front of us or in the experience of those in this on this panel. So,
thank you.
I guess my comment there is, or my response is that, yeah, I think it's so important, and I've heard this many times today, to be able to change our perspective, to think differently. And then when we are representing children, we need to do that, to really listen to the children and hear what they're saying and be able to switch our views and be open to switching them to think different ways.
So I just had a question with respect to the disproportionality of Indigenous children in care. Do we know whether that number has gone up over the years, or is it going down?
No, it's for sure it's going up. I think, just in BC, for example, we have legislation which really involves Aboriginal communities. When that legislation was passed in 96, the numbers were in about 43. A few years ago, it was 52. Now it's 54%. And what we're seeing is that a lot of those kids in care have parents who were in care and have grandparents that were in Indian residential school system. So it's sort of like taking a rock and throwing it into the middle of a smooth water surface, and you just see reverberations. And in this system, what those reverberations are is that once you get in a generation of involvement, the likelihood of further involvement increases. So it's going up for Indigenous people and down for the rest of the population.
And what, if any, views would you have on how to change that?
Well, I have a very strong view about it, and I think it's on a panel tomorrow. And that is, I think that part of what's happened is that because we're making children's rights sort of like a parental-child issue, that for Indigenous children, that's not the right equation. The right equation for Indigenous children is to look at their nation. They're citizens of nations. They have broader social connections. So to reconnect and re-involve on a broader level, I think, is the answer. And it's also the attack on those broader connections that has caused the problem in the first place.
My next comment would be more for Barbara. With respect to the concept of children growing up and making that determination whether to be male or female, why is that determination required at all?
Well, I usually start these talks by asking people if they know what their gender is. And then I ask them, how do they know? And then I say, and suppose somebody messed with your genitalia, would you still be whatever your gender is? The fact is, we all have a sense of gender which is so profound and so much a part of who we are that actually choosing is the wrong word. It's recognizing the gender that we are.
But why does the definition need to be male or female? Why can't there just be a neutral between the two?
Oh, actually, good question. Some people suggest that we should have male-female other or male-female trans, for example.
Or just
is that
neither.
Where you're going?
No, I'm just saying there shouldn't be either.
If I'm with you. I'm with you. I mean, certainly, there are some legitimate reasons to collect information about gender. Not many.
All right, thank you.
And male-female other is the bullet on the target on the forehead of anybody labeled other. And just as an indication, my friend Wallace Wong is a psychologist with the Delta School Board. He has 80 trans kids in his practice from that school district.
Actually, my question is actually being asked already, but I really feel like I want to still come up here. My question is actually that I'm a youth settlement worker working specific with immigrant youth. So Barbara, I want to thank you for acknowledging that racialized youth are facing a lot more difficulties when finding out their identities. And for Harriet, that I hear you that, and I'm sad that you went through all those tough times with the administration and the teachers at your old school. I'm also a trained teacher, BC certified teacher, and that I know that through my education program, I learned so little about the LGBTQ community. And what I really learned a lot the most is from the community and from real people like yourself. So thank you again for sharing your story. And so the gentleman before me asked the question that the work that I do right now on the form that I actually insisted on putting beside the gender columns when I asked my youth for registration form, female, male, and other. And the reason being that we kind of talk about it out, if we scratch that out, giving them the freedom is to choose what they are, but at the same time, not having this conversation about who they are. But then that actually, I learned a lot by saying that actually by putting other is actually quite offensive. So,
well, it's on a form it's better than, but some people want to put it on the passport, for example. My intake form says, "What is your preferred pronoun?"
Okay, so that would be a great suggestion. Thank you very much.
Let's thank our panel.